Okay, we're gonna go ahead and get started. So thank you everybody for attending this event, brought to you by the ABA's International Criminal Law section. Today we have Marisa R. Bassett, who's going to be talking about universal jurisdictions and its developments. A little bit about Marisa. So she is an institutional capacity building attorney at the Defense Institute of International Legal Studies. In this role, she assists foreign partner defense institutions in Eastern Europe in building legal capacity, including on the law of armed conflict and human rights. Before joining DILS, Marisa was an Assistant Appeals Counsel with the International Residual Mechanism for Criminal Tribunals, which is the successor to the International Criminal Tribunals for the former Yugoslavia and Rwanda. There, she prosecuted major political and military leaders for genocide, war crimes, and crimes against humanity. She previously served in the ICTY's Office of the Prosecutor, Appeals Division. Marisa is a member of the Justice Rapid Response roster of experts on investigating sexual violence in conflict, and she is the co-editor of the Economic Sanctions under International Law, Unilateralism, Multilateralism, Legitimacy, and Consequences. Marisa, thank you so much for being here today and talking to us about universal jurisdiction. For the members in the audience, if you have questions as they come up, please feel free to use the question and answer feature, and we'll be answering them towards the end. Marisa, I will turn it over to you now.
Great. Thanks for having me. I'm really happy to be here. So as Hannah said before, my current job, I was a prosecutor at the ICTY, and then the body that was the successor to the ICTY, which is decidedly not a body that deals with universal jurisdiction. It's very much international jurisdiction. But when I was there, I became kind of interested in universal jurisdiction because I had a lot of interns or alums from my my university coming and asking me, how they could work in the field of international criminal proceedings or atrocity accountability, when this has arguably been a very much a shrinking field over the past 10, 15 years. And it seems to be growing a bit now, more with some recent developments at the ICC, but at the time that I was sort of dispensing that advice, that it was definitely most international courts were closing, and there wasn't a whole lot of like new prosecutions opening. It was also around that time that the independent investigative mechanisms for Syria and Myanmar were getting started. I'll talk about those a bit later, but essentially they're bodies that are intended to assist jurisdictions put together cases to prosecute under universal jurisdiction. So I knew about the concept of universal jurisdiction from back when I was in law school, but that was 15 years ago, and we had spoken mostly about just the Pinochet case, and it was kind of a novel idea that wasn't really being used anywhere. But then I started paying attention, and there was a lot more out there since then. So today I'm going to start talking about what universal jurisdiction is, just to kind of give a primer for people who might not be as familiar with the concept. And I'll also talk about some other forms of extraterritorial jurisdiction. Then I'm going to talk a little bit about why we're hearing more about it recently. And then I'm going to discuss some recent developments in the field. So that will be some expansions under legal frameworks, and then into some cases and trends from 2024. And then I'm going to close with a section about what we're seeing on universal jurisdiction here in the United States. And I hope that will take about 25 minutes, and then we'll do some Q&A. So starting out, just basically, what is universal jurisdiction? Universal jurisdiction is a mechanism that allows states to prosecute grave international crimes, typically those for which there might be international jurisdiction, but when those crimes occurred outside the territory of the prosecuting state, and when neither the perpetrator of the crime nor the victim is a national of that prosecuting state. Typically, for universal jurisdiction, the perpetrator still has to be found in that state, so there needs to be an ability to establish personal jurisdiction over the perpetrator, unless states allow for trials in absentia, which is generally pretty rare. I briefly want to talk about two other forms of extraterritorial jurisdiction called active and passive personality jurisdiction. these are not pure forms of universal jurisdiction, but sometimes these cases kind of get lumped in with universal jurisdiction or confused with universal jurisdiction because they are universal jurisdiction adjacent, because they allow the prosecution of crimes that didn't occur on the territory of the prosecuting state. But they do have a jurisdictional hook that is different, and that is that either the perpetrator or the victim of those crimes are found in that prosecuting state. So when we talked about active personality jurisdiction, the perpetrator is not just found in the prosecuting state. The state is exercising jurisdiction because the perpetrator is a citizen of that prosecuting state or a national of that prosecuting state. And then in the case of passive personality jurisdiction, which is less common, that's where a victim is a citizen of the prosecuting state. So what is going on with universal jurisdiction these days? So for many years, universal jurisdiction was not a very active field. And the most famous case I mentioned that you would have heard about probably was the Pinochet case, where that former Chilean dictator was arrested for genocide and terrorism and murder in 1998 when he just happened to be in the United Kingdom. And he was eventually released on health reasons. He was never tried in the UK. But that was kind of a wake-up call. People were like, oh, maybe, there's people who commit these crimes, particularly high-level leaders like this, can't just go wherever they want. There's the ability for them to be prosecuted in other places. But after that happened in 1998, we didn't hear much about universal jurisdiction for like 20 years. But in the past, let's say decade, maybe 8 years, we're seeing it being expanded a lot. And the question is why? One reason is that there are some conflicts that are occurring now that are resulting in horrific crimes. They're just not going to be easily addressed through international mechanisms. We have these international ad hoc tribunals or special courts that were established, and now we have the International Criminal Court. But there are a lot of crimes that are occurring that are not going to fall under the jurisdiction of any of those kinds of courts, particularly the ICC, which is in many ways the only international kind of game in town at this point. And these crimes are not going to be addressed domestically. So there's little hope that these crimes are going to get prosecuted unless they're prosecuted elsewhere. So Syria and Ukraine were kind of the drivers of this, particularly starting with the post-2011 crimes in Syria, but now looking more at Ukraine. Syria is, of course, not a party to the International Criminal Court, and Russian Security Council vetoes would mean that the situation is not going to be referred to the ICC. Now, things have changed in Syria in the past 2 weeks, and maybe there's the possibility for some domestic prosecution. We'll see what happens. But until very recently, that didn't look like it was any kind of possibility either. And in Ukraine, again, it's a bit different. There is jurisdiction now at the ICC over Ukraine, and the ICC has issued warrants for 6 people, but it seems unlikely that any of them are actually going to be arrested anytime. So again, we're seeing people looking for other methods to find remedies for crimes, potentially for lower level perpetrators. At the same time, however, we're also seeing universal jurisdiction be used in connection with atrocities that occurred a long, long time ago. There are a number of active cases still today related to the 1994 genocide in Rwanda, mostly in France and Belgium. And there have been both extensive international and extensive domestic prosecutions for all levels of offenders for the genocide. But the universal jurisdiction use there is probably more a result of the large number of perpetrators and the fact that a lot of them were able to escape detection by moving to and claiming asylum in different European states. Finally, another reason that we see expanded universal jurisdiction use is the really tireless work of civil society organizations in making this happen. It started mostly that a lot of these organizations were, again, involved with Syrian victims who had escaped Syria and were elsewhere. And the civil society organizations have really been cooperating with prosecuting authorities, involved in litigation in whatever manner might be permitted in that jurisdiction. That might be filing complaints or working as victims counsel or civil parties in suits, or working as amicus. So a variety of ways that they would be involved, but also involved in advocacy efforts to change laws, to make it easier, to allow victims to participate more. So that's been another significant trend. And finally, as I mentioned, there are these two UN mechanisms that were established, one for Syria and one for Myanmar. And they're part of the UN system. And these mechanisms are partnering with civil society organizations and conducting their own investigations to create dossiers on alleged perpetrators that it can then provide to competent jurisdictions to assist in investigating and prosecuting these individuals should any of these suspects be found in states where there is some applicability of universal jurisdiction or other extraterritorial methods of jurisdiction. And we've seen prosecution of a case in Germany that was assisted by the Syria mechanism in 2022. And just last week, actually here in the United States, in the Northern District of Illinois, there was an indictment unsealed against two Syrians for war crimes that I guess that the Syria mechanism assisted in that bringing about that indictment. So that was an interesting development just last week. Before I start getting into the cases, I want to talk about a few developments in legal frameworks that happened that are relevant to universal jurisdiction. And the first is the Ljubljana, The Hague Convention, which was signed in February of this year. And civil society groups were really active in pushing forward this development. That convention is a treaty, and it primarily deals actually with transnational cooperation in criminal prosecutions. So things like, evidence sharing and extradition. But in addition to those provisions, it also requires states that are signatories to criminalize and establish jurisdiction over core international crimes when there is no recourse to extradite the suspect. So basically, it obligates states to create universal jurisdiction based on presence alone for war crimes, for genocide, for crimes against humanity. And more than 30 states have signed that convention since the signing opened in February. Now, that's not a whole lot of states, but it does include numerous states outside of Europe where universal jurisdiction is not typically being used. And it includes one state that's not party to the Rome Statute, the state of Moldova, where I was actually last week. And that's interesting because, again, signatories to the Rome Statute have to domestically criminalize these crimes. Another expansion of universal jurisdiction that actually occurred in the end of 2023 was in France, where it was confirmed that France can now prosecute crimes against humanity and war crimes that were committed in Syria under universal jurisdiction. Previously, lower courts had ruled that those crimes could not be prosecuted in France because Syrian law did not criminalize those crimes as such in its law. But the Cour de Cassation overruled these earlier rulings in the end of 2023, relying on the fact that although Syrian law doesn't criminalize those crimes as international crimes, as such, it does criminalize the underlying acts like murder or rape or torture, even if it doesn't classify that as within the sort of framework of international crimes. Currently, this decision is just limited to Syrian prosecutions in France, but observers sort of anticipate that this might signal a lowering of barriers to the use of universal jurisdiction overall in France. So I'm going to get into some trends here and talk about some specific cases that were active in 2024. Now that I've gotten through these structural background developments. The first trend is not really related to any specific case, but it's just that more and more states are actually now opening investigations based on universal jurisdiction. There are only 13 states worldwide right now that have active cases in litigation under universal jurisdiction, and that might actually be an overcount depending on how you look at it, because different organizations that are counting are also counting cases that are brought under active and passive personality jurisdiction. But in terms of opening investigations, we have seen a number of new coming states to this field. And a lot of this has to do with Ukraine and to a lesser degree, Belarus. So we've seen investigations opened in states like Estonia and Lithuania, which previously didn't have any active work in the universal jurisdiction area. Another interesting trend is that there's been a movement to toward using universal jurisdiction to bring about corporate accountability for atrocity crimes. You know, in the past, let's say 20 years, we've seen a number of creative ways to hold corporations or their officers to account for links to international crimes. So here in the US, for example, we've seen the use of the Alien Tort Claims Statute. But of course, that's not a criminal statute, right? But in the past few years, we've seen attempts to use criminal statutes and use universal jurisdiction for corporate accountability for persons, for individual criminal responsibility, so officers of different corporations. Probably the most notable of these cases is the London oil case in Sweden, and that began in 2023. And there, a Swiss oil executive, Alex Schneider, who was co-indicted with a Swedish national, have been on trial for aiding and abetting war crimes in what is now South Sudan. And that case has been going on and is expected not to conclude until 2026, which is making it a very long case. It deals with the displacement of populations in an oil-rich area of what is now South Sudan, although the facts of the case were before it was actually South Sudan. And that displacement also entailed the commission of a variety of other crimes like rape and abduction by employees of London Oil. There are also 3 interesting prosecutions in a similar vein going on in France. One for a media company where the facts go way back to the 1994 Rwanda genocide. A cement company where officers are being prosecuted for complicity in crimes against humanity in Syria. And the one that I thought was really interesting was that there's a tech company that's also being prosecuted in France, or tech company executives being prosecuted in France for complicity in torture and forced disappearances in Libya and Egypt, because the tech companies, they had provided surveillance technology to these states, and then that surveillance technology was being used to facilitate abductions. And interestingly, in that case, the company is actually a party to the prosecution as well. So the company is being prosecuted as well as executives. The third trend is about prosecution of women. It's still a very small percentage of cases involving atrocity crimes involve prosecuting women, but that's been coming up more and more in Syria cases where women who are connected with ISIS played a role in imprisonment and sexual violence against Yazidi women. And the bulk of these prosecutions, like the bulk of Syria prosecutions in general, are occurring in Germany. But this fall, Sweden also indicted a Syrian woman for these kinds of crimes. I don't know if anyone listens to the podcast Asymmetrical Haircuts, which is a really interesting podcast, which is all about international jurisdiction and international law. And they did an interesting episode this past year on prosecuting female jihadis. So if you're interested in that topic, I'd say look it up. It was a good podcast. I liked that one. The last trend, or sort of more aptly put, problem, is the advanced age of the accused in a lot of these cases. This isn't really a problem that's specifically linked just to universal jurisdiction, but rather to prosecuting atrocity crimes overall. There's no statute of limitation on these crimes, right? And for the cases are also very complex, and they have significant political and financial hurdles that they have to get over in order to get to prosecution. And that leads to sort of delayed justice, or unfortunately, some cases, injustice denied because the perpetrators become ill or die. The last case that was being prosecuted at the successor body for the ICTR closed in late 2023 after it was determined that the accused in that case, Kabuga, was determined unfit to stand trial due to his advanced age. And there are a number of universal jurisdiction cases, again, related to the Rwandan genocide, again, in France and Belgium, where this is becoming an issue because we're 30 years on from that genocide, and most of those suspects are very, very old people at this point. So I want to wrap up by talking just a little bit about the landscape of universal jurisdiction here in the United States. It probably doesn't come as a surprise to any of you that the United States doesn't have a lot of experience using universal jurisdiction, but it does have a good deal of experience with other forms of extraterritorial jurisdiction. And even the US is not immune to this trend in Europe of universal jurisdiction. It's starting to sort of reach us here. In theory, US courts can exercise universal jurisdiction over crimes that fall under certain US statutes. Those include the genocide statute, torture statute, child soldier statute relating to the recruitment of child soldiers, and the War Crimes Act. So those are core international crimes. The US does not have a crimes against humanity statute, so there's no ability to get jurisdiction over those crimes, be it universal jurisdiction or another type yet. All of those statutes that I just mentioned, under which there's theoretically universal jurisdiction in US courts, require the presence of suspects in the US. Without the presence of suspects, the cases can't go forward. We don't have in absentia trials in the US, even though in some states they do. But although I said in theory there is universal jurisdiction under all of those statutes, in practice, generally we've seen that the US is hesitant to use that, and they require more than just presence of an individual in the US. Not just finding the person here, but some other jurisdictional hook. The full-scale Russian invasion of Ukraine has been a factor in the US as well. The war crimes statute in the United States didn't previously allow presence alone jurisdiction, so any type of universal jurisdiction. But in the end of 2023, President Biden signed into law an amendment to that statute that allowed the War Crimes Act to now include a jurisdictional provision where the, quote, offender is present in the United States, regardless of the nationality of the victim or the offender. So this closed a gap in the War Crimes Act to allow for the exercise of universal jurisdiction under the War Crimes Act. And that's jurisdiction over grave breaches of the Geneva Conventions and violations of Common Article 3. And in December 2023, shortly after that amendment was signed into law, the Department of Justice brought the first ever charges under the War Crimes Act, although they brought them under passive personality jurisdiction. And those are against 4 members of the Russian armed forces for unlawful confinement, torture, and inhuman treatment of a US national on Ukrainian territory. And as I previously mentioned, last week, there was an indictment unsealed that dated only from November. So it's a recent indictment in the Northern District of Illinois. And that is the second case we've seen under the War Crimes Act in the United States. It's against 2 Syrian officials for war crimes of cruel and inhuman treatment at a Syrian prison that occurred between 2012 and 2019. But again, at least some of the victims in that case were US citizens. So again, it's extraterritorial jurisdiction, but passive personality jurisdiction. Other places that the US uses extraterritorial jurisdiction. In terrorism related cases, that often happens, those events often occurring outside the United States, but sometimes the effects of those crimes are seen in the United States, so that's a bit different. Recently, 6 Hamas leaders were indicted for terrorism and for murder of US citizens in Israel on October 7th of last year. So again, a bit different. Those are not core international crimes, but again, it's a use of extraterritorial jurisdiction for major crimes here within the US. Another place that we see these crimes being prosecuted in the United States is under the torture statute. And that was first used about 15 years ago against the son of former President Charles Taylor of Liberia. His son, Chucky Taylor, was tried here for torture that was committed in Liberia. But Chucky Taylor was a US citizen. He happened to be born in the United States. So again, not a universal jurisdiction exercise. The second ever prosecution under the Torture Act is underway now in the state of Colorado, however. And that trial is going to begin in April. And that case is called the Correa case. And the facts come out of torture committed in the former regime in the Gambia. And interestingly, this seems to be the sort of most universal jurisdiction, real true universal jurisdiction example that I've seen prosecuted in US courts. The defendant is not an American citizen, and he appealed, alleging that there was insufficient nexus to the United States with regard to his indictment, and that appeal failed in early 2024. The judge noted the universal condemnation and repugnancy of torture in determining that there was indeed jurisdiction over him, despite the fact that he's not a US national. And from what I've read, it's a little bit unclear, but it's possible that one of the victims, although not all of them, or not even the majority of them, might be a US citizen. So maybe it's not really fully universal jurisdiction, but it's definitely a lot closer to it, given both the dicta of the case and also the citizenship of the individual who's being tried. So that sort of concludes my my comments. So I'm happy to open for questions now and hear what you have to say.
Thanks, Marisa. So to the audience members, if you have a question, please use the question and answer function. So far, we have a few questions. So the first one is universal jurisdiction considered only a possibility, an actual right of a state, or an obligation of a state to prosecute perpetrators of the most serious crimes? In other words, is a state obligated to prosecute perpetrators under universal jurisdiction, or does a state have a choice to prosecute perpetrators?
I mean, I think that it's more of a choice. States have an obligation to criminalize these crimes, and they have other obligations because these crimes have achieved jus cogens status, and they're crimes under customary international law. So even in theory, if they're not criminalized, customary international law would dictate that they're still crimes. But how a state chooses to exercise its jurisdiction is a different matter, and that's a policy choice of the state. So, states may or may not choose to prosecute, and they may or may not need necessarily to adopt statutes that allow them to prosecute, depending on what their legal systems look like. So I wouldn't say it's an obligation, but I would say that maybe we're slowly seeing states begin to think that, as we see this being used more and more as a mechanism.
Great. The next question we have from the audience. So this one has a little bit of background before the questions. So, the United States has universal jurisdiction over genocide and torture, yet the State Department issued an opinion that Mohammed bin Salman of Saudi Arabia has head of state immunity in the U.S., preventing his arrest or lawsuits against him in the United States. There were even U.S. laws passed by Congress and signed into law denying head of state immunity to those who ordered torture or genocide. And the question is, will federal prosecutors use universal jurisdiction to indict persons who committed torture in Syria, Myanmar, Saudi Arabia, Ukraine, and other countries?
So yes, immunity is an issue, and that so heads of state technically do have immunity for criminal prosecution. However, that immunity does not typically extend to things like torture, genocide, crimes against humanity, because those are not considered official acts under, you know, the immunities for prosecution is against prosecution for official acts. Those Jus Cogens status crimes, customary international law crimes, cannot entail immunity because they shouldn't be undertaken as official acts. Whether the U.S. will use universal jurisdiction to prosecute such people comes down to a number of factors that are mostly policy choices. As I said, those statutes, including the two that the questioner asks, the genocide statute, the torture statute, theoretically do allow universal jurisdiction. Now, whether they choose to, whether the Justice Department chooses to exercise jurisdiction in that manner is really something that's up to them. They could do it, they could choose to do it because they definitely have the ability. But as I was noting before, there is not any precedent of those statutes currently being used that way. So that would be an innovative and interesting way for them to be used, and definitely a legally permissible one. But one that the Justice Department might not use because they might be concerned about it. And there's no precedent. It doesn't mean that there can't be one, but it looks like the practices that they're looking to try to have additional jurisdictional hooks in the hope that the cases would succeed. I would say, given the incoming administration, there's less likelihood that we're going to see a lot of use of pure universal jurisdiction in the United States these days, just because it doesn't seem to be a priority or a policy preference of the incoming administration. So, that's basically my thought on it. And then, but you do have a law, correct? That the immunity doesn't apply and that these statutes can be applied that way. And, as I said, you're seeing it inch in that direction. But I don't foresee that being something that is definitely going to happen anytime soon here in the US.
Great. So kind of following off that question of where we were talking about immunity, another question was essentially, how does amnesty play in universal jurisdiction? So can a person who's been granted amnesty by a state where the crimes took place be prosecuted in another state under universal jurisdiction?
I'm not aware of any universal jurisdiction cases where the person being prosecuted has claimed that they have amnesty. But that doesn't mean they don't exist. I just maybe am unaware of them. They're, as I was saying, that these crimes are Jus Cogens crimes, and part of that that status of crime is that amnesty is not permitted for that type of crime. It is contrary to customary international law to grant an amnesty for those kinds of crimes. So I would suspect that states would not accept a domestically, I've been granted amnesty for this crime, so therefore we're not going to prosecute you for it. So I would expect that most states that do use universal jurisdiction would also be inclined to not accept an amnesty as a part of a defense. And I have not, like I said, seen any cases where amnesty has been pled, but I do know that there are a number of cases. There's jurisdiction from international courts that says this. So there's jurisdiction from the Special Court for Sierra Leone, from the ICTY and from the extraordinary chambers in Cambodia that talk about amnesty's non-applicability to these major core international crimes. All those cases, I believe, deal with war crimes, but I imagine that you would have similar arguments made about crimes against humanity, genocide.
Gotcha. So speaking of the international courts, another question we got is, how is it possible to prevent double standards towards the ICC? So, for example, for the same crimes, Putin must be arrested, but not Netanyahu. How do we prevent a double standard from being created?
That Putin was indicted for crimes and Netanyahu was not. I'm sorry, I missed that piece of the
Yes.
question.
So the question is, for the same crime, there's this push that Putin must be arrested, but not Netanyahu. So how do we prevent double standards in the ICC?
Well, I mean, unfortunately, that's politics, and I don't think that's the ICC itself. The ICC has issued, warrants for both of these people, and if the ICC ever has the ability to arrest either of these people, I'm sure that they will get those people arrested. I mean, the problem being, of course, that the ICC doesn't have a police force, right? So they rely on the police forces of states or UN to conduct these arrests if there's UN civil police or something, and then a peacekeeping operation or something. And I think that I don't think that double standard is coming from the ICC itself. I think that double standard is coming from politics and states. And I think that the poster, the person who asked the question probably is talking a little bit in relation to France's recent announcement that it wouldn't arrest Netanyahu. So, I like I think it's not going to be at all controversial to say that Israel Palestine is a particularly fraught situation with regard to pretty much everything, and that different states are going to have different policies on this, and a lot of states are not, they're going to do what they're going to do. And although France and many other states, not the United States, who are party to the Rome Statute, have an obligation to arrest these leaders if they come onto the anyone who's been indicted by the ICC, if they're on the territory of that state. We also have seen that not happen. We have seen that Omar al-Bashir was not arrested in South Africa when he attended Mandela's funeral. And we have seen more recently that Putin was not arrested in Mongolia when he went to have meetings with the Mongolian president earlier this fall. So, I guess that says that maybe Putin is also not going to be arrested, but I don't think that the issue is about prosecution of them. I think it's really about the politics of whether they actually ever end up within the jurisdiction of the court actual physically there.
Thank you. So this question is a little bit different. So the question is, how does cyberspace impact the principle of universal jurisdiction? For example, does blocking the internet by an authoritarian regime be considered a violation of Jus Cogens under universal jurisdiction, that access to cyberspace is a human right?
Um, so the cybersphere plays a big role in international law that's obviously continuing to develop and be, it's just fascinating. Where is cyberspace? Where are you actually physically located when you're operating in cyberspace? And as the person who's asking the question, the piece of their question relates to the fact that we can't always know where cyberspace is, but we can know where its effects occur, right? So if you block the internet in China, the effects are in China. So, that's maybe where we would say that crime's occurring. I would say that honestly, my real knowledge about cyberspace comes with how it applies to international humanitarian law and not necessarily how it applies to international criminal law. So this is me kind of spitballing a bit here, but I think that I would say that I think there's definitely the possibility that there could be effects in cyberspace in a state where there could be, international crimes resulting from that. However, I would not say that blocking the internet is something that would occur, that would fall within that category. Because my thought about that is, I mean, right now what we're talking about as crimes over which there's universal jurisdiction are really just crimes against humanity, war crimes, and genocide. And although human rights violations are indeed, bad, they're not within that category of offenses. Additionally, human rights violations and particularly actions such as something like blocking the internet are usually things that are taken, steps that are taken by states, right? And when we're talking about the use of universal jurisdiction, we're talking about individual criminal responsibility of people. So human rights violations, we don't usually try individuals for human rights violations, with the exception of torture, which is also a crime. Human rights violations are something for which we see state liability usually, and that's not criminal liability usually. So it may be a crime, but it would have to be, first there would have to be an individual, so that could maybe be a head of state. But second of all, I don't really see that as a crime that is sort of codified in any way that would allow for universal jurisdiction.
Thank you. So speaking about the difference between, prosecuting the individual versus like state liability, what you were just saying. One of the questions are, so can a government or just individuals be prosecuted under universal jurisdiction? For example, can the Syrian government be prosecuted, or does it have to be individuals within the Syrian government?
So universal jurisdiction is used for crimes. It's criminal. So again, it's really about, individual criminal responsibility, not state responsibility. There is no criminal jurisdiction over states. There can be some confusion about this because there are certain violations that are both criminal and non-criminal, right? So we have like genocide. A state can be liable for genocide, or individuals can be criminally responsible for genocide. And those are different things. So something like state responsibility is usually for something like a human rights violation or a violation of a treaty like the Genocide Convention. So, state responsibility is typically done in it's a liability. It's not a criminal responsibility. Nobody goes to jail. You can't put a state in jail. So we see those kinds of prosecutions. We see those kinds of cases come up at the ICJ. So there we see genocide, and there you'll see, for example, Bosnia versus Serbia was a genocide case, but it was not a criminal case. It was a case about responsibility and the interpretation of the genocide convention, not as a crime. I guess that the way that I can see, the other issue that comes in here is immunity again, right? So like, we say that states are immune from criminal prosecution in the United States under Foreign Sovereign Immunities Act. Usually can't. Foreign Sovereign Immunities Act is usually seen as you can't sue a state, but the wording of the Foreign Sovereign Immunities Act leaves open the possibility of immunity if a state is going to be held criminally responsible for something. Now, again, I'm not aware of any cases in which a state is being held criminally responsible, and all case law about the application of, for example, the Foreign Sovereign Immunities Act in the United States is about civil liability. We have talked about about criminal responsibility today a little bit with regard to corporate entities. States and corporate entities are obviously different, but corporate entities are considered, people under most law, so they can have criminal liability. But again, you can't send a corporation to jail, so it doesn't look exactly the same. And so I think that the only place that I can really see the idea of holding an entity responsible that might be sovereign or quasi-sovereign would be something like a state-owned corporation. I'm not aware of any cases in which like a state-owned corporation has been prosecuted under universal jurisdiction, but I might see that as the way in to, quote unquote state prosecution.
Yeah, thank you. Sorry, we're just bombarding you with questions, but the audience has a lot. So another question we got is, could the ICC Assembly of States Parties move to amend the Rome Statute to authorize an ICC police force? And then the person who asked the question said, as far as I know, this couldn't be vetoed at the UN Security Council.
As far as I know, it could not be vetoed at the UN Security Council. I agree with that. Whether that is something they, in theory, could do, maybe. I think it's highly, highly unlikely for that to be something that the Assembly of States parties is going to do. I mean, the whole idea of jurisdiction in general is particularly for international jurisdiction, is that it's based on agreement and consent, right? And I don't see that a lot of states are going to allow the creation of a police force that is not controlled by a sovereign entity, because I think that there would be some strong issues there with how that would relate to consent. But also, I mean, I just politically can't imagine states agreeing to that. I also can't imagine how that would function. I think it's an interesting idea, and sometimes I wish that happened, because I feel like, you know, we see all these cases and we're just like, oh, that's never going to get prosecuted. You know, there's no hope that they're ever going to get Putin, that they're going to ever get Netanyahu, because they know well enough to not go somewhere where they're going to be arrested. But I think states are more worried about some kind of uncontrolled international police force running around the world arresting people.
Thank you. So you mentioned just a couple like high-ranking officials versus low-ranking officials during your presentation. So one of the questions is, so it seems that low-ranking officials are generally prosecuted under universal jurisdiction, especially in European countries. Why is this the case, and why aren't high-ranking officials more often pursued for investigation and prosecution?
A number of reasons. The first is very practical, in that in order to, you know, actually try someone under universal jurisdiction, in the vast majority of states, that person needs to, they need to actually have that person, right? And high-ranking officials are recognizable and know better than to travel somewhere where they may be arrested and tried. The second piece of that is I guess immunity, right? We talked about whether there's immunity for heads of state, and, you know, in theory, there's not immunity for heads of state. I mean, legally, it's not supposed to be immunity for heads of state under for these kinds of crimes, but it doesn't mean that certain states might not try to interpret it that way. It's definitely an area of law where there's a little bit of room for, there's wiggle room, and like I said, there's, you know, domestic jurisdiction on this differs, even though domestic jurisprudence on this differs, even though there's international jurisprudence that is clear on it. And I mean, I think that also it's more likely that heads of state would end up indicted by an international court than a lower level offender, right? So I think that there's some, in some ways, deferring to bigger bodies for you know, heads of state or high-ranking officials. That being said, France hasn't issued an arrest warrant for Assad for chemical attacks in Syria, and that has stood. You know, French courts have not said that that's not permissible. So there's no, you know, immunity that seems to be, you know, being applied to that particular situation. But, you know, will they ever get Assad in their, you know, in detention in their country, in their custody? I don't think so. So I think that that's kind of one of the reasons. I think that most typically what you see in these cases of universal jurisdiction is that one of these perpetrators ends up in this state, you know, whether that is not necessarily as a national, because then they would not be universal jurisdiction, but maybe they're, you know, traveling there, maybe they're a refugee and they're passing through there, and then somebody kind of sees them and says, hey, I know that person worked at a prison. This person tortured me, 15 years ago in wherever, because and that's typically what you see. You don't typically see these cases against, big. That's the prototypical case, right? It's not every case, but that's what the cases, a lot of the cases that you see in Germany and in France are like, or years later, it kind of catching up to people that way.
Thank you for your insight. And this may be our last question because we are towards the end of time, but I do want to encourage the audience, if you do have any more questions, please submit them now in case we do have extra time. But what are the advantages and difficulties in investigating and prosecuting a person accused of committing a crime in another territory that's possibly thousands of miles away?
Um, I mean, the obvious advantages is that you can actually have the trial, right? In many of these places, as I was saying before, the reason people are turning to universal jurisdiction, that states are turning to universal jurisdiction, is because to go back to Syria, for example, there's no functioning judicial system there. These people are not going to be tried domestically, right? So that's obviously an advantage. Another advantage is safety, the safety of the victims who might be maybe key witnesses in the case, the safety of the child not being a political target and subject to violence in a state. Um, so those are obvious advantages, right? The drawbacks are that it's hard to investigate a case that's where all the facts are thousands of miles away from you. Um, Now that's changing because a lot of, like I was saying, a lot of civil society organizations are well connected with refugee groups and immigrant groups, and are able to help gather that evidence. And those people aren't necessarily in the state where the crime occurred any longer. But the locations are there. Any documents might still be there. So it's just harder. There's more hurdles. Um, the the other issue is that it has to do with how the case is viewed, and is it viewed domestically in the place where the crimes occurred as legitimate, right? And that's tied in with the connection of buy-in, understanding, and whether and how these cases are supposed to play a role in reconciliation, and establishing the truth of what actually occurred, making sure that there's some record of facts. And when cases are tried far from where the crimes occurred, there's frequently less, local populations will frequently look at them as, oh, hey, that's exceptional. Look, they did something nice for us somewhere else. Or this is completely illegitimate and it's politicized, and we domestically do not accept the results of this case. And it happened so far away, it's going to have its outcome is going to have no role on helping the society heal, or even will the outcome of the case be accepted. It can lead in the other direction. I'm not saying that legal cases, trials they're not the best way to heal a society or to establish a historical record, but they do play a role in that, right? Like, nobody's out there thinking that the ICC is going to heal Darfur. Like, that case gets prosecuted, doesn't get prosecuted. It's not like suddenly everyone in Sudan is going to get along and they're going to put differences behind them and there's going to be peace and reconciliation and happiness. But it helps. It plays some role, right? And it also, the fact that certain facts are found and found beyond a reasonable doubt, and there's evidence and it's written down in a case, helps establish a historical record so that at least certain things can't be denied. And when that's done in a foreign state, I think arguably that's even harder than when it's done at the international level.
Thank you. Just wanted to thank you, Marisa, for coming and talking about universal jurisdiction and answering all of these questions. To the audience, I hope you learned something, got your questions answered. We really do appreciate you coming. So just wanted to flag for everybody. In January, we will be having a webinar on state responsibility, and we look forward to seeing you guys then. Thank you so much for coming, and thank you, Marisa, again.
Thanks, Hannah. Have a good day.